Good morning, everyone. Welcome to the Infinity Workforce Solutions Fast Forward webinar series. My name is Steve Kessler, and I'll be the host of the program today. We do want to thank you all for joining us today. I know for a lot of us, school is either just starting or is about to start here very soon. So there's a lot of activity, a lot of work that needs to be done. So we're very happy that y'all are joining us this morning. And I have to say, we have a really important program today. The title is Avoiding the Bumps, Legal Hot Topics in the World of Student Transportation. And I think for the most part, this deals mostly with students with disabilities. So you probably hear some talk about Individuals with Disability Education Act and maybe something about Section 504 in the Rehabilitation Act. So it's a very exciting program. Just a few housekeeping items before we get started. Everyone that's logged in to the webinar is muted, so we can't hear you. So if you have a question that you would like to pose, you can either type it into the Q&A box there or into the chat box, and we can see those coming in. So we'll try to take those questions that you have. Generally, we try to do that sort of at the end of the presentation, but we'll make sure we leave time to get your questions answered if we have some. So why don't you all, if you don't mind, just jump on the chat and type in who you are and where you're from so we can kind of know who's out there. And while you all are doing that, I want to introduce our guest this morning. We're very privileged, I believe, to have what I think is probably one of the top education attorneys in the country. So Betsey Helfrich has pretty much dedicated her professional career to education law. Betsey has successfully represented school districts' clients against a variety of claims in state and federal court, as well as special education, due process hearings and appeals, including the Eighth Circuit Court of Appeals. Betsey is a recognized leader in special education law, providing general counsel, litigation defense, and consulting for schools in all areas of the Individuals with Disability Act and Section 504 of the Rehabilitation Act of 1973. Betsey also serves as an independent hearing officer under Section 504. Assist schools with drafting and implementation of Section 504 policies and procedures, and hosts numerous workshops regarding 504 for school personnel. Betsey frequently presents nationally and locally in all areas of education law. Betsey is a routine presenter at the Council of Administrators of Special Education Annual Conference, LRP Annual National Institute on Legal Issues of Educating Individuals with Disabilities, the annual Pacific Northwest Institute on Special Education and the Law, the Tri-State Regional Special Education Law Conference, the Transporting Students with Disabilities Conference, and numerous professional development trainings across the country. So Betsey is a very busy person, and we're very thankful that you're joining us this morning. So without further delay, Betsey, I'm going to turn it over to you.
Thanks, Steve. Good morning, everyone. Thank you for that really nice introduction. I'm really happy to be here with you guys today as we are at a very busy time, back to school time. My own children are still at home, so I hope you don't hear them in the background. I have a home office. I'm ready for them to go back to school. But I am a special education attorney based in St. Louis, Missouri, where I'm streaming to you today from. I represent public schools in IDEA matters and Section 504 matters, and I am really lucky to have been introduced to the transportation world and speak at the TSD conference in Frisco and then some state conferences around the country every summer. And I love presenting to you guys. I know we have a lot of you on the line. So if you have questions, as Steve said, please put them in the chat. We'll try to answer them throughout because I think what you do is so important and so overlooked. Particularly in the area of special education. So every time I present to a group of transportation professionals, they say, thank you for talking about the IDEA to us and Section 504 and legal hot topics, because generally most, you know about the IDEA, but as transportation directors, you are expected to implement it, follow IEPs on the bus, safety plans, And I really think it's important to go over some of the basics in those areas and then really focus on what's new so you feel current in that area of the law. So that's what we're going to do today is really kind of keep a focus on special ed and what if I were in your shoes, I think I would want to know. A lot of my family's in the school world, teachers, paraprofessionals, administrators. So I always come at presentations with the thought of if I were them, what would I want to know? So that's what we'll do today. So just in general, some numbers I think it's interesting to look at. So in the United States, we educate about 50 million students every year. That's a lot of kids. And you guys are helping to oversee getting them to school every day, which could not be more important. And you transport about 26 million kids that take the bus every day. That's a huge responsibility. So much comes with it. There's so much on your drivers. It's almost like you're magicians. Rerouting routes every day, driver shortages, safety on the bus. What you're doing is amazing. So what we're going to focus on a little bit is of those 50 million children, how many are identified with students with disabilities? And the numbers fluctuate, but about 12 to 15% of those students are IDEA eligible, meaning they have been identified to have a disability under the IDEA. So we've got about 7 million students across the country going to public schools that have a disability under the IDEA that also sometimes requires specialized transportation, which we'll talk about. Just a little background. I just think it's nice to kind of go back to the basics. Some of you are pros, been around a long time. Some of you are newer. So just a little bit of some basics about the IDEA. I don't think it hurts. It was first passed in 1975 by Gerald Ford. It was the Education for All Handicapped Children Act. And sometimes you still hear it referred to that as the EHA. If you have that in any handbooks or anything, I would change that and update it to the IDEA. I do see that sometimes in handbooks or on people's websites. It's still referred to as its predecessor. So make sure everything's current. IDEA is the current verbiage we use now. The IDEA is a funded law. So every school across the country that receives federal financial assistance from the Department of Education, which I assume is all of you on the line, we have to follow the IDEA. There is some money tied to it. Schools get reimbursed for certain things. Obviously, in the transportation world, transportation buses, that comes along with it a little bit too. But it is a funded law. Because it's funded, we have to take proactive steps. We have all kinds of guidelines and regulations. It's kind of like the transportation world. It's highly, highly regulated, the IDEA. We used to reauthorize the IDEA about every 10 years and get new regulations, so current laws to support the IDEA. But the IDEA hasn't been reauthorized since 2004, so 20 years ago. And there's really not a lot of movement on this right now to see any new rules. So when COVID hit, people would say, well, what does the IDEA say about virtual instruction? And I would say, well, it says nothing. Because it was drafted in 2004. We didn't even have iPads in 2004, right? Think of how much school life has changed since 2004 with school violence and school shoot. A lot has changed since 2004. So the IDEA is fairly outdated, especially with transportation. I'll show you what it says about transportation. But just know, IDEA, last reauthorized in 2004, we're dealing with sort of an outdated law, but not nearly as outdated as 504, which we'll talk about. Under the IDEA, if you've been around in the school world or a part of an IEP team, you hear the word FATE all the time. FATE, FATE, FATE. I remember my kids came to watch me present once at a transportation conference, like, what are you saying? FATE? What is that? Well, that's really the crux of the IDEA. That means a free and appropriate public education. So meaning if a student with a disability requires an extra level of support or a special bus, we can't charge that family more for the extra cost. It has to be free. FATE means it's individualized for that student. So we can't blanketly say all students with disabilities have to ride this one bus or all students with disabilities have to go to this one school. It has to be individualized per the United States Supreme Court. So when you hear FATE, it's individualized. It's what does that kid need to make progress based on their unique needs. FATE is really the cornerstone of the IDEA. You'll hear it a lot if you go to an IEP meeting, which we'll talk about your participation at IEP meetings. Our friend Section 504. So you guys probably hear that a lot too. 504, 504, they have a 504. Well, Section 504 is really almost like a chapter or a title. It's Section 504 of the Rehabilitation Act of 1973. That's where it comes from. This was passed by Richard Nixon as part of the broader civil rights movement. Section 504 applies to every school across the country that receives federal financial assistance. So everybody listening has to follow 504. Even charter schools, depending on your situation, have to follow. The difference is it's not funded. There's no money tied to Section 504. So if we think a student needs something under Section 504, the district is paying it out of their own dollars or different dollars in the IDEA. So that's a little bit of a difference. Another difference is Section 504 is truly just a non-discrimination law. The IDEA is telling us to reach goals and to do something proactive. Section 504 says, schools, you guys figure it out, but whatever you do, don't discriminate. It's truly a non-discrimination law. So what's on the screen here is really the whole language of Section 504 that says any program we have as a school, include our transportation programs, we can't discriminate. We have to make sure they're non-discriminatory. This includes any program we have as a school. So that also includes field trips, extracurriculars, the band. The band's going to go to California to play in the Rose Bowl. And I've heard this before. Hey, it costs extra to rent a bus that's wheelchair accessible in California. So we're just going to tell that student they can't come. Because being in band is an optional program. So we can tell them they can't come, but that's not true. Any program we have has to be non-discriminatory, even if it's optional, even if you don't have to participate in that field trip, even if you don't have to try out for the football team. If we offer it as a program, it has to be non-discriminatory. That's what 504 tells us. There's so much more to it. I can do all day 504 trainings. That's not what you want to do today, but it's important to know what 504 is. What's interesting too, we looked at the IDEA numbers, and about 12 to 15% of students in your district and across the country are probably IDEA eligible. The current numbers for Section 504 are only about 3% of your student body are 504 eligible, most likely, if your school's on track with numbers. So this keeps creeping up, but really it's a lot lower number than the IDEA. Missouri's at 2.7, so it'll kind of be interesting to see what your state is currently. Section 504, something brand new you might hear about. This section talk about being dated. The IDEA regulations were last reauthorized in 2004 and implemented in 2006. The Section 504 regulations were last reauthorized in 1977, and they have been sitting since 1977. I wasn't born in 1977. They are so outdated. They're very confusing. So if you feel like, oh, man, our school does not have a handle on 504, we're all over the place. Well, that's because it is confusing. The regulations are really old. They're really not clear. And so I feel like there is a lot of confusion about 504. So if you feel that way, you're not alone. In May of 2022, the U.S. Department of Education announced they're going to be coming out with new Section 504 regulations for the first time in 45 years. We haven't seen those yet. So stand by. So you might hear some buzz about new 504 regulations, but they're not out yet. Okay, so that's a little background on both laws, but I really want to tie it to more practically, what does the IDEA say about transportation? And what would I want to know if I were you about the IDEA and how to really make your department run smoothly? So the IDEA, when you see at the bottom of the screen here, CFR, that's the Code of Federal Regulations. So that's what's been around since 2006. The IDEA does consider transportation. It mentions it in the actual language, and it's considered a related service. So you might hear that in IEP meetings, or the special ed director might say, yep, they have transportation as a related service in their IEP. That just means the IEP team for the child decided this student needs transportation in order basically to get to school safely. Because of their disability, they're required to have transportation because otherwise they couldn't get to school in a safe manner. And that is an IEP team decision if they need transportation as a related service. Just because transportation is in an IEP doesn't mean it has to be on a certain kind of bus, or it really doesn't mean anything unless they put it in the IEP. So some schools just check the box saying, yes, transportation is needed as a related service. But you can also write in, I'm sure some of your schools do this too. Hey, it needs to be an air-conditioned bus. They need a ramp. They need an aid. An aid is also something that you could write into an IEP that they need an aid on the bus. There's no set requirement. Hey, if they have this disability, they have to have an aid. Or if they have this, they need an aid. It's always an individualized decision. And I would encourage you to not be afraid to speak up as the driver or the transportation department lead if you think a student needs an aid on the bus, because that is certainly something a team can do. It's not always the answer, as you know. We have some really sad cases where the aid really didn't help at all, but sometimes it helps a ton, helps that driver. So you can put that in an IEP. You can also put it in a 504. So 504s can also dictate transportation, and they also can dictate important things like allergies. You might see a 504 if a student has a peanut allergy. That would be a situation you would see a 504 and maybe not an IEP. And that bus driver needs to be aware of an allergy in a 504. And we're going to talk a little bit about that later, of what can be shared and what drivers can know, because you hear a lot of things, oh, that's HIPAA protected, and that's not really true. And we're going to kind of break down those myths. But just know IEP and 504, they can both address transportation. How do you know if it's required? How do you know if a child needs transportation in their IEP? Well, it really is, in this quote from OSERS, which is part of the Department of Ed, says, it's the IEP team that has to decide, is transportation needed? And if it is, it should be described in the IEP of what is needed. So the IEP should be pretty clear. So if a stranger picked up that IEP, they would know exactly what to do. If a student moved in from a different district and required some sort of special transportation, you would hope that it was pretty clear in that IEP of what's required. So this is kind of an interesting case. I like to study the cases in this area. So if a parent disagrees with an IEP team or a school saying, you didn't provide transportation as a related service in my child's IEP, and I thought they needed it, or I thought my child needed an aid on the bus, and the school says no, a parent has a right to file a due process. That's what it's called. It's under the IDEA. It's basically a lawsuit under the IDEA that the parent can file, and it's free to file. And you don't have to be represented by an attorney. So a lot of parents represent themselves. Some states, they have a ton of attorneys. New York has a zillion due processes. Missouri, we don't really have that many. It'd be interesting for you to see what your state is like. But a parent can file a due process, which is essentially a lawsuit saying, I disagree with the decision you made, and I want a different outcome. And a hearing officer / kind of judge, it's not usually like a formal judge, they get to make a decision and say, yep, you have to put this in the IEP, or no, you don't have to. So we like to study those cases because it's kind of interesting to see how they come out, just so you know in the future. But why I like this case, I thought it was interesting, was this was a 6-year-old student with autism and a language impairment. And the student moved to a new district. And that's where you see a lot of turmoil, so to speak, is one district had all these things in the IEP that they provided for the student. And then the student moves to a new district, and the new district isn't willing to do the same things. And that's what happened here. And the student's former district said, we will provide curb-to-curb transportation for this child. So the student moves to the new district, and mom says, okay, we'd like curb-to-curb transportation, please. And the school said, we don't really think, based on what we're seeing here, we don't think they need transportation curb to curb. So they did a transportation assessment, and they studied the student a few days getting on and off the bus. And they determined the real issue wasn't what on the bus. The real issue was once they got in the building, they had a tendency to kind of get lost. And so the school did their own transportation assessment before agreeing to something in the IEP to see what was truly needed, and they won. So they offered the student a one-to-one aid once they got to school to help them get into the building and into their classroom safely. And the school won this because the IDEA gives discretion to the IEP team to determine what's necessary. You don't absolutely have to adopt a new IEP exactly what the other school sent you. So on that note, I want to talk a little bit about that. The IDEA doesn't define what curb to curb means. They don't define what door to door means. Your state law may, so it's something I want to know as a leader of the transportation department. Does our state law, do we have any sort of manual that says, here's what door to door is, here's what curb to curb is? If you don't, Here's what it means. It means what the parent thinks it means. So if you notice a student's IEP says door to door, but you know that driver is really just coming up to the edge of the driveway, that's something we need to rectify. Because an IEP is like a contract. So if the IEP says door to door, and mom thinks that means we are coming to the front door, opening the door, receiving the child, putting them on the bus, and then taking them to the school and delivering them to the front door of the school, then that's what it means. So some schools I've heard when I do training, they say, Betsey, we always just put door to door. That's just a standard part of our IEP. And I would encourage you to, if that's your practice, to change it. Befriend the special ed director. You guys should meet frequently, frankly, and talk and say, hey, here's what I've noticed as the transportation director. We keep seeing door to door. This child does not need door to door. Our driver's having to get off the bus. It's delaying the whole route. And this child walks out fine. We can change what an IEP says, but through the T process, we have to reconvene. Or maybe next year when you're drafting the IEP, you don't put that in. But the driver themselves can't amend an IEP, say, hey, that's not working. We don't go door to door. Once it's in there, it's a contract. So we do have to speak up early or even come to the meeting. Some schools say, oh, no, we can never have our drivers or our transportation department come to the meeting. Well, you probably don't have time to go to every meeting. But the truth is there's nothing in the law that says you can't go. So particularly in a really dicey situation, you should speak up and say, hey, I want to come to the IEP meeting before it's put in the IEP that we're going to be going down this muddy embankment. Let's talk about it. Because once it's in there, it's too late to take out. So I have this scenario here. Bobby Brady is the head of the school's transportation department. He gets a call from one of his drivers who drives a special need route. The driver's bus got stuck in the mud that morning while trying to exit a rather steep driveway. After listening to the distress of the driver about the sticky situation, Bobby states, today is your lucky day. I know that parent well, and they will be okay meeting you at the top of the driveway from now on. I'll call them and tell them about the change. This is very common, right? There's many cases about this where, hey, something changes. There's water on the road, there's mud. If it's just one day we make a change because of weather, not a big deal. This is very common where the parent says, yeah, that's fine. You know what? We'll just come to the top of the driveway from now on. And that's okay until it's not. Okay? Because the burden is always on the school to follow the IEP. So again, a day or two, it's muddy. That's fine. We do what it takes to be safe. But if for the rest of the year, we're planning on, the IEP says door to door, but we're just going to go to the top of the driveway from now on. That's not something we can change by ourselves. The IEP has to change. And that's exactly this case from New York in 2018. So student had multiple disabilities. The IEP itself said door-to-door transportation. And previously, a bus would go down the driveway and there was a little turnaround pad in the driveway and the bus would turn around, get the student, go back up. Well, in the winter, it started to get muddy on the driveway. And the driver correctly said, this isn't safe anymore. I can't do this, which is fine because, again, safety is our number one concern. But they just called the parent and said, hey, from now on for the rest of the year, we're just going to come to the top of the driveway. And at first, mom said, sure, that's fine. I'll wheel the kid up there. That's fine. Well, it didn't become fine when mom got really cold. And it's February or March. And she's wheeling the child up this long, steep driveway. She gets mad. And says, my IEP says door to door. It's not muddy anymore. You need to come back down and get the kid at the door like we agreed. And the district said, no, from now on, we're going to stay at the top of the driveway. And so the parent filed a due process, a lawsuit, and the parent won. Because the IEP said door to door. It wasn't defined in New York what door to door meant. So the court looked at what did the parent think it meant. The parent thought it meant what they did for the whole first half of the year was come down to the concrete pad, come to the door, get the child. And by changing it, even with mom's consent, they violated the IDEA because they changed the IEP without going through the right process. So what could they have done here? They should have reconvened the IEP team. And as a team, decided to take door to door out. Because once it's in there, we have to follow it. It cannot be up to the driver. It can't just be with, oh, yeah, the parent says, that's fine. train your drivers. If they're going to make a change from what the IEP said, they really need to talk to you, and you need to talk to the sped director and go about it the right way. Now, again, a day or two, it's icy, it's snowy, just survive and be safe. But if you're making a change for the rest of the year, that's something you have to properly address. This is a very, very common situation. Okay, how about gated communities? Lots of cases on this. I think this is interesting. I'm from Missouri. We don't have a lot of gated communities, but this case is from California. And I think there's a lot of gated communities in California. Again, a 2018 case. This is a rather large student. He was 16 and physically large, over 6 foot, male student with autism, educational autism. He was nonverbal. He had seizures. He didn't often have control of his body movements when he was agitated. So he and his IEP had many accommodations, but one of those was an IEP that specified curb to curb transportation. Again, it matters how we're riding in the IEP. Curb to curb and door to door are not the same thing. Are we saying the nearest safest bus stop? If we say nearest safest location, we better be sure what that means, and we better have notes saying what that means. Okay, because I see vague things like that all the time, and it really can lead to trouble. So you have to be specific. And again, you're not at all of those meetings, but maybe a conversation with the SPED director saying, hey, I've noticed these are how they're being written. We need to clarify. Okay, large student, parents live in a gated community. And the previous school year, what happened was the bus driver on the first day, dad met the bus driver outside the gates of their community with a key fob and said, here's the key fob for the year to get you through the gate. And so then from then on, the bus driver just sailed through the gates with the key fob, picked the student up right outside of his driveway, took him to school. Well, it's a new school year when this case hits. There's a new driver. And so on the first day, dad says, hey, I'll meet you. Come on through. And the new driver says, no, our company's policy is we cannot drive in gated communities. Okay, so my company was a new company that the district contracted with, and they said, our company, our insurance won't let us come through gated communities. And dad said, hey, I don't care about your insurance company. You need to come get my kid. And the bus driver said, no, I'm not. And so, of course, dad's angry. He calls the superintendent. And the superintendent says the same thing. Hey, we have a new bus company. We can't make them go through the gates. And dad says, well, my child's IEP says you're going to come curb to curb. And that means the curb outside my driveway. So you do need to come through the gates. The superintendent digs in. Parent files a due process saying you violated the IEP. And the court agrees with dad and says an IEP, like a contract, cannot be changed unilaterally. And policies promulgated by the Transportation Department do not override the district's obligation to implement the IEP. So there is nothing in your insurance or your privately contracted bus company's contract that can override the IDEA. The IDEA always trumps. So if we are contracting with an outside company that says, hey, we can't go in gated communities, or hey, we don't do this, be mindful of that. And before you sign that contract, say, actually, we do need you to go into a gated community. Can you do it? Because if not, we might contract with somebody else. Or just know if we can't contract with somebody else, we as a district have to find a vehicle that can go in that gated community. So the district lost this because we made a unilateral change to the IEP and it didn't fly. So if we say curb to curb, we do have to figure out how to get in there, even if it's a gated community. So before you write it in, we need to know the situation. Is it safe? And we need to write it accordingly. Steve, any questions about that before I go on?
I'm sorry, I had to unmute myself. One question that this is really, really good information, but I have a question about in cases where, they've gone through due process and the parents won the case, are there ever damages awarded? Are there any fines or penalties associated with this?
That's a great question, Steve. So under the IDEA, you don't see an award of monetary damages. The IDEA is like a personal remedy. So the court can say, parent, you were right, so we do have to go pick you up. They might give some compensatory education and say, you missed school for a week because you couldn't get to school, so we are going to offer you tutoring or makeup services.
Okay.
The only money that comes in under the IDEA is if the parent was represented by an attorney. The school district might have to pay the attorney's fees for the parent, which sometimes can be up to $400,000. So it is a risk to the school. Now, so no money damages under the IDEA. 504 though, if it's a discrimination lawsuit. So you didn't let me go on the field trip because you said it cost more for me to rent the bus because of my disability, and that's discrimination. Or hey, you didn't let the students with disabilities go on the field trip. Under 504, you can sue for monetary damages for discrimination. And you are seeing that more and more. So that's where the money lies, is discrimination. So that's something just to be aware of for everybody listening. If you have some practices at your school that you're thinking of, you know what, I don't know if we do that right, or we tell students with disabilities they can't be in a certain club because we can't get them to the other school after school hours. Those are things we need to really focus on, because that's where the money damages come in. So that's a great question. So a little bit different. IDEA, no money damages. 504, money damages.
Can be. So there's
it is lengthy. No one wants to go through due process. Your teachers are on the stand. Your bus drivers are on the stand. It's very intimidating. A lot of parents are now live broadcasting these due processes around the country and like through other parent advocacy groups. So a lot of people are watching you live while you're testifying. No one likes that. So they're very intimidating. So it's just not a position you want to be in. I will say this as a side note to the transportation directors listening. It's back to school time. Obviously, you're planning back to school training through your driver's FERBA training. Keep records of every single driver who listens to those trainings, because I have been through litigation where the parent will say they weren't even trained. And you say, yes, we were. Every year back to school time on August 30th, we watched the confidentiality video, whatever it is. And the plaintiff's attorney will ask for the sign-in sheet. And I see a lot of schools that say, oh, we didn't have everybody sign in. We just had the entire bus barn watch the video together. Always keep a sign-in sheet from every single driver who watches your back to school trainings. And also keep the materials, because it can go a long way to protect the driver. If they can say, because right now we're talking about IDEA compliance, but obviously there's a lot of safety, bullying, tragic accidents. Keep every single person's login if they're watching, or a sign-in sheet. So just a side note.
Okay, we're going to go for a subpoena to be issued for that sort of information.
Absolutely. So a few things. FERPA, parents can request their own kids' records, right? So any emails internally between the transportation department, be mindful of what you're putting in email. And then subpoena, that you're on litigation, can really get anything. And they will 100% ask, either through a subpoena or the discovery process, for training materials and who signed it.
Fantastic.
We could talk about IEP implementation literally all day. I have a zillion like really interesting cases, but you get it. We don't have that much time. The point of this section is just be really, really mindful of how you're writing IEPs, and that we aren't making any unilateral changes. And if needed, you show up to that IEP meeting and say, hey guys, let's talk about this. Just keep in mind too, I think the driver shortage is hopefully maybe getting a little bit better. I'd be interested to hear your thoughts. You might disagree, but one thing I keep seeing litigation on for when times were really difficult just after COVID is we're again pulling off magic tricks, getting kids to school and rerouting things. Be really mindful that we aren't shortening the school day for students with disabilities. So students with disabilities per the IEP have a certain number of minutes they're required to get. So if we are loading up the special needs classroom first, because it takes longer, right? So there is some practical aspect to that. But if they're missing a chunk of their day because of transportation needs, that would be something liability would come from. And there are many, many cases on that. And the courts are really cracking down on this. So just be really mindful that we're not shortening students with disabilities day because of transportation needs. Really important. You're seeing a lot of discrimination lawsuits on that. Don't forget, there is an option under the IDEA if we cannot find a driver, or for some reason they do live down a muddy bank and we just cannot safely get them there. We can always offer for parents to transport students under the IDEA. We can't make them, but if they volunteer and say, hey, I don't mind, or if it's part of a discussion, we can pay them the IRS reimbursement for mileage rate. I would not pay them an hourly rate because then they're an employee transporting a student. They probably don't have the proper certifications for drivers and the certifications that you require in your state. So be mindful of that. Again, this is something you go through with the special ed director, but it is an option to reimburse parents under the IDEA to drive their kids to school if we cannot figure out a way to safely transport them, particularly when we have students that are placed outside public agencies or they're going to a private school for behaviors or autism or something like that. So I always like to put that in. It's an option to consider and sometimes really helps some difficult situations. I want to talk about, I'm going forward a little bit. I do want to talk about FERPA and what you can share, because I think that's really important and sometimes overlooked. And this is true for general education students and IDEA students. Student confidentiality is governed by FERPA. That sounds like a rodent, right? But it's the Family Educational Rights and Privacy Act. So here's a little scenario. Mom sends the school a note that says, since Greg has been very ill, he can only eat certain foods. Even though students are allowed to eat snacks on the bus and are known to trade snacks, the school's front office doesn't want to share this note with the transportation department because they don't want to violate HIPAA. Is that true? The answer is no. So when we're in the school environment, HIPAA doesn't really apply. It's FERPA, the Family Educational Rights and Privacy Act. And FERPA governs any record we maintain about a student, even if it's a medical record. So even if we got a note from mom about health or we get a note from a doctor, once we take possession of it as a school, it's governed by FERPA. So this is a lot of training and just communication with your nurses, because sometimes nurses are the ones that are very hesitant because they have been trained in HIPAA. But the truth is, under FERPA, we can and need to share with those who have a legitimate educational interest in the info. This includes people we contract with. So sometimes there's a myth that, well, we use an outside company to do our transportation. We contract with X bus company, so we can't share anything. The truth is, FERPA says, yes, you can. If we are contracting with somebody to perform a school function, we can share information. So we have to think, there's no FERPA police. You're not going to go to jail because you violated FERPA. But man, could there be serious consequences if we don't share information about an allergy with the driver who needs to know it? Absolutely.
Yeah.
Or a student who has a heart condition. So you don't want to send every IEP and every 504 to every driver. That's overkill. It would have no purpose. But there does need to be some really good communication between your nurses, your special ed department, and you as the transportation department. How are we sharing information about allergies and heart conditions and EpiPens? And how are we sharing that with sub-drivers? Because this is where you see a lot of litigation is, hey, somebody's driving a different route. We're rearranging things all day, but Mia, there's a student with some really high needs on this bus. How are we sharing that information? Because unfortunately, you see a lot of really sad cases where a student might pass away in the classroom because it's a sub in there and they're not sure of the emergency procedures. So back to school time, really think, how are we sharing information with drivers? What do they need to know? Again, I don't think sending every IEPs has any effect at all. Maybe a cheat sheet of, here's what you need to know on this route. If there's a training for that student who has a special seizure condition, maybe we invite the bus driver. I really think that's an important step that we could probably correct this back to school time of how we share info. The Department of Ed even clarified that bus drivers are entitled to information under FERPA. They have a whole thing about it. You guys get it, but there is no world where we can't share information with the bus driver. Really, anyone in the school environment, even a volunteer, a parent volunteer for a field trip, as long as we say, hey, you need to know this about the student you're helping chaperone today, please don't redisclose this information, but that's okay. So also, the IDEA contemplates in itself that we can provide any information to a service provider. And the bus driver could come to the IEP meeting. Again, not that they want to do that. They have a lot going on. We need them on the bus. But it technically, there is nothing wrong with the driver coming to an IEP meeting and getting the information they need if that's something you thought was appropriate or necessary, or you yourself could go. And also you sharing information, what that driver's seeing could be really relevant to the IEP team. So saying it early and often before the IEP gets drafted is important, and really training your drivers to do that. Again, just keep in mind, anything we put in writing in the school environment can and shall be read in a court of law someday. So if you see drivers sharing information, sometimes you have, I did a training once where the drivers, the transportation department were all on like a group me chat. And they were surprised to learn that when they were talking about kids in that group me or things that happened on the route, that was subject to subpoena. And it turned out to be very embarrassing for all the drivers. But everyone is so professional, doing their best. They just said a few things that maybe they would be surprised that somebody would read later. So just kind of remind your drivers, remind everybody that, because it can be embarrassing later that you put something in writing that maybe you would be embarrassed to have somebody read someday. There are special rules. I wanted to take your questions too, but I just want to talk a little bit about student discipline. So we could have a whole separate thing on student discipline, but if you are eligible under the IDEA or Section 504 as a student, you are entitled to extra protection when it comes to student discipline. So what that means is the law has contemplated if a student with a disability gets in trouble under the IDEA and gets suspended from school, if it's more than 10 days in a school year, they have to have what's called a manifestation determination meeting. So you might have heard of that, MDR manifestation. And what the point of that meeting is, it's a team of professionals to get together and say, did the student engage in this conduct because of their disability? So they have an emotional disturbance and they call out, they say shocking statements as part of their disability. And when they are on the bus, they made a threat or they made a shocking statement because they can't control it. The team has to get together and review that. And the law says, this is the IDEA, I did private, but it says, hey, if the student did this conduct because of their disability, we cannot suspend it. So I think that's important to say, because I think sometimes drivers are like, wait a minute, I just kicked this kid off my bus yesterday. And the superintendent just told me he has to come back on my bus. That might be because of the required manifestation and determination meeting under the IDEA, and 504 requires it as well. If it's related, they cannot be suspended even from the bus. And that's hard sometimes. Because, hey, they just hurt somebody. What do you mean they have to come back on my bus? Or they brought, now there's exceptions for drugs. There are some exceptions. But where you see this a lot of times is ADHD and impulsivity. Well, they did something in the classroom and we're going to suspend them. And the parent says, well, they're impulsive, they can't control it. And so you have to have this big meeting called the manifestation determination meeting. If it's related to their disability under the law, they cannot be suspended. And that includes from the bus. If it's not related, they can be suspended. So bus suspensions count towards that 10 days if, as part of their IEP, they have transportation as a related service. So the IEP really dictates a lot. So if their IEP says, yes, they need transportation as part of their IEP, and then they get kicked off the bus for more than 10 days, that manifestation meeting would be required. So again, what happens on the bus, that communication, the driver knowing their disability and perhaps knowing how to de-escalate for the child. If there's a behavior plan for the child, the driver knowing that. If there's a training about that child, that driver could be so important. Because your driver needs to understand that. Why is this kid keep coming back? I just kicked them off. It's because the law might require it. That area of the law is really interesting. I'd be interested to see if it's going to change. But that's how it stands right now is more than 10 days in a school year, a student gets disciplined. You have to do a manifestation meeting. If what they did is related to their disability, they cannot be suspended. And again, you see a lot of litigation over that. We can talk about that all day, but I just kind of wanted to throw that in because I think that's something that maybe isn't talked about with drivers. Is that part of the law and why you might see some interesting things. So again, train drivers, if there's a behavior plan, if there's something that driver needs to know about de-escalating the student to keep them safe, they need to know. So in general, again, there's so much to know about the ID in 504, but the basics are just be mindful of discrimination. Are we treating students differently because of field trips or transportation? Could we do better on that? If an IEP says door to door or curb to curb, we cannot change it ourselves as a transportation department. It has to go through the IEP team, but speak up, right? Ask to come to that meeting and participate if you think the IEP as drafted is putting your driver in a difficult or dangerous situation. It's good to speak up. Let's amend this. Let's get this right. Or speak up before the meeting so we don't put that in again. Be more specific. tell your special ed directors, please stop riding nearest safest location. Because what does that mean, right? Really speak up and communicate. They can go a long way to avoid these type of lawsuits. Don't forget, back to school time, sharing information, reminding drivers what we put in writing matters. And also, let's open the lines of communication so your drivers are safe and know what they need to know. But I'll stop now just to see if there's any questions or any discussion we want to have. I kind of flew. There's so much we could talk about in this area. Try to kind of pick the highlights of what you need to know at back to school time.
Yeah, thank you, Betsy. It amazes me every time I hear about these topics, how much you have to know to transport students with disabilities. It's crazy. And we do have some questions here.
Great.
I'm going to kind of take them in the order that they came in. Here's a question from Dan. Dan's asking, can IEP be amended with the school district and parent agreement? Is it that simple?
Yes, it can be amended with the district and parent agreement. So again, if the parent just says, it's fine, that's not an amendment. There's formal paperwork that goes along with it that your special ed director would know. But yes, you don't always have to reconvene the whole team if the parent agrees. And there would be special forms and paperwork. If the parent doesn't agree, it says, I don't know, then you would need to convene the whole team and talk about it and go through the proper channel.
Very good. Here's another question. Must special services and curb to curb be provided for late transport after school, stayed for an activity after school?
Possibly. Yes. It depends on what the team decides. Now, if you don't offer transportation to any other student for after school activities, right, then maybe you don't have to for the student. That would be an IEP team decision though, of, hey, but we want this child to be able to participate in extracurricular. And if we don't provide transportation home, they can't. It might be something you want to do, but it doesn't always have to. Again, it's individualized.
Okay, I think kind of a follow-up question here is, must special transport be provided to daycare after school for ESE and 504 students?
Again, not must. It would go back to, do you provide transportation to other students to daycare or to home? A lot of schools do, especially for ESE, like early childhood, because they're coming for a half day. So I would say most schools do. There's nothing in 504 that says you have to do this. They would just say, don't discriminate. If you do it for other kids, you need to do it for our disabled kids. So again, it's not like a broken record, but there's nothing in the law that says you have to do this, you have to do this. It's individualized and non-discriminatory.
Very good. One other question here. Must bus staff administer medication on the bus, let's say for seizures?
Oh, such a good question. We could have talk about that as well. There's no rule that says bus drivers can't administer this or this. Nurses can delegate administration of medicine. As long as somebody is trained, and every state law might be a little different, then a driver and aide could administer medication. So it's really, again, what the team decides. Some districts say our drivers will not be trained on administration of emergency medication. I will tell you those cases, the school blues. Okay, if they have a blanket rule, we never train our drivers, we will not, blanket rule, don't succeed. If you have just a practice of saying, we determine case by case what that kid needs. In general, we don't have our driver do it. We like to have an aide on the bus if it's going to be needed because the driver is there for safety. But I would not have blanket policies that say our drivers will never do X and Y. Because again, if it's not individualized, the court won't like it. So in general, it's okay to say, hey, we have an aide that provides emergency medicine. But there are cases where they say, no, that driver got to be trained too. It's interesting because I get it. That driver's trying to drive. We don't want to worry about administering rectal seizure medication. It's a scary, scary thing. But again, I would just never say never. I wouldn't have blanket policies that say our driver will not do X. Don't put that in writing. You say, hey, we do what it takes for a kid. We're going to come up with individual situations. That's all it takes.
Very good. I don't see any other questions popping in right now, but one thing I do want to say, you talked several times about the need to properly train the drivers about a lot of this material that we talked about. And it's very important also to document that training. And And frankly, Infinity Workforce Solutions, that's kind of what we hang our hat on. You can deliver the training through the system. Everybody is tested on the content, and there's a date and timestamp recorded document of that training, and also a certificate of completion is produced for each one. So I know we have a lot of our customers out there. Certainly, they are fully aware of what we can do. But if there are any school districts out there would like to know a little bit more about us, I popped this little poll up on the screen. And also, and this is kind of my commercial part here, a lot of school districts need school bus drivers. And I want to remind everyone that we are a registered provider for entry-level driver training for the theory portion. So if you have drivers that need a Class B CDL, or perhaps you have drivers that need the school bus endorsement, for example, we have that material as part of our system, and it's a good, efficient way to provide that for the needs you may have for your school bus drivers. So just wanted to pop that out there. And I don't see any other questions coming in, but I will say, Betsey, I really enjoyed this presentation. We've had a lot of requests for the recording of this because some folks couldn't make it. So I will thank you once again for this this great bit of information. And sounds to me like there's 2 or 3 other topics that we need to have webinars about that we could bring you on and talk about. So I don't see any other questions. So Betsey, I'll just thank you for your time this morning. Thank you all very much. Thanks to everybody that's attending. This was one of my favorite programs so far this year. So very much appreciative of your time, Betsey, and all those out there that joined us this morning.
Thanks for having me. Good luck, everyone, the new school year.
Thanks, everybody.
Thanks.
Bye.
Bye.